All right. Let's get situated here. All right, as you can tell, we've had a change of panel. This case was added onto the docket, SEAMAN versus SEAMAN, and so I know I don't need to make this introduction, but to my right, we've got Chief Judge Carrie Evander from Brevard County, and then Judge Rand Wallace from Orange County. And we're ready to go with the last case, SEAMAN versus SEAMAN.
Good morning.
Morning.
May it please the court. Phoebe Wise on behalf of Casey Seaman, the appellant, and I'd like to reserve 5 minutes of my time for rebuttal. This is a dissolution action, and it's an appeal from a post-judgment order denying the husband's objection to sale. And here, we're arguing that the trial court grossly abused its discretion in failing to order the re-advertisement and resale of the property where the record indicated some sort of collusion and inadequacies with the bidding process. And I'd like to start by discussing the inadequacy of price.
Well, I'd like to begin by discussing your client's initial bid on the property. What was that?
Mr. Seaman did not bid on the property.
Never. Never. Did he attempt to bid?
At the auction sale, no, he did not attempt to bid.
Was there testimony that he had someone bidding on his behalf?
I don't believe that there was any testimony in the record that somebody was bidding on his behalf. I do believe that the court in the order indicated that Ms. McCathan was bidding on Mr. Seaman's behalf. But
Well, the clerk who testified, isn't that what the clerk said, that he believed that she was bidding on his behalf?
the clerk testified that he believed that Ms. McCathan was bidding on Mr. Seaman's behalf, but there was no indication as to the record as to why he believed that.
Right,
His
and there was no other evidence. That was the sole evidence on that fact, and the trial judge, I guess, accepted that testimony.
I would submit to you that there was evidence when you listen to or look at the testimony of the clerk that Ms. McCathan did put down a deposit, and that the deposit could go towards any property. Other than that, there was no indication when she put the deposit down, or there was no testimony as to anything that Ms. McCathan ever said to the clerk or anyone else that would have led anybody to believe that Ms. McCathan was bidding on behalf of the appellant, Mr. Seaman.
Okay, but that was the testimony of the clerk, and no one explored it further.
The testimony was simply that he believed that Ms. McCathan may have been bidding on behalf of Mr. Seaman, but there was nothing else.
And why is it that you think the clerk would give that testimony with absolutely no support?
I'm not sure.
Does it make any sense that the clerk, a witness from the clerk's office, would come in and randomly testify to a fact like that?
I can't speak as to why the clerk may have said that. There was no indication as why the clerk may have said that,
Okay,
or
but
any information.
Okay.
if the clerk, since the clerk did say that, and there was no other evidence on that point, was it error for the trial court to accept that testimony? And to reach the conclusion that the trial court did? That Ms. McClathan, or whatever her name was bidding on behalf of your client?
I think that what the trial, or what the judge, ultimately the conclusion that the judge came to in the order was that Ms. McCathan admitted at some point in her testimony, or conceded that she was bidding on behalf of Mr. Seaman, but that never came out in her testimony, and I'm not sure, frankly, where Judge Bass got that from.
Did your client deny that?
Mr. Seaman was not present at the hearing. He did not testify at the hearing.
Okay. So there's no evidence contrary to it?
That is correct.
And why wasn't your client at that evidentiary hearing?
He chose not to be there, Your Honor.
But assuming the judge could accept that testimony and that this individual was bidding on behalf of your client, then it seems like your client was trying to do the exact same thing you're alleging was wrongful by the former wife, but just that the former wife executed the plan better than your client. Would that be a fair statement if, assuming that that individual was bidding on behalf of your client?
I don't know that I would agree that that's necessarily a fair statement. I think that there is a big difference in this case because between the relationship that may exist between Ms. McCathan and Mr. Seaman and the one that exists between the wife, the attorney, and the father pointing towards the collusion. Your Honors can take judicial notice. I know that the dissolution proceedings were up here on appeal just recently, and it is appropriate for you to take judicial notice of the facts established on the record in that dissolution proceeding. And I think that it's important to note that in those proceedings, on the face of the record, the father here paid for the attorney's fees, paid for a place for her to live, paid for, I think, a car.
Was this argued in your brief?
Yes.
You've argued the facts from the other case in your brief on this case?
No, we've simply noted that Your Honors can take judicial notice of those facts. We did mention...
But you didn't argue that in your brief, is the point I'm making. And so you're coming here today and making an argument that you didn't make within your pleadings.
I believe it is raised in our brief in the statement of facts, and I believe in our initial argument under point 1, we discuss the father's relationship with the wife, and
the trial court had those facts as well, correct?
correct, the trial court
Trial
did.
court found no collusion, correct?
Excuse me?
Trial court found no collusion, is that right?
That is correct.
Okay. And the trial court had the ability to judge the credibility and the witnesses, I mean, obviously not your client, because your client chose not to appear, correct?
Correct. At the hearing, Ms. Seaman was present, and the clerk and Ms. McCathan, they all testified as well as counsel.
Would there be collusion if the former wife's father intended to, eventually give the house to his daughter, but the daughter, being the former wife here, was not aware of it? Would that be collusive?
I believe that,
Because the trial court found that she was not aware of it.
right, that was her testimony. I think that it would still be collusion based on the father's heavy influence in the actual dissolution proceedings, and the fact that the father was well aware of the equalizing payment and the specific amount of the equalizing payment, and all of the facts related to the dissolution. I think that speaks towards the collusion.
Now, was there an independent bidder in this case?
There was an independent bidder who I believe placed a bid of $15,000.
Okay, and then when that bid wasn't accepted, then that bidder didn't make any other bids, correct?
Correct. After
And
that, I believe Mr. Cooper made some bids, and Ms. McCathan made two or three bids.
Okay. And is that evidence of the reasonableness of the bid? That the one independent bidder wasn't willing to go over $15,000? Also, of course, they take subject to the mortgage.
whether $15,000 was
Sure.
reasonable bid.
Wouldn't that be evidence as to the reasonableness of the bid?
I don't think in this case it would go towards the reasonableness of the bid. Here, the inadequacy of the price goes back to the appraisal value of the farm, which the wife and her attorney continuously argued throughout the dissolution proceedings in the amount of $410,000. During that time, the husband was trying to get the amount to be less, but the wife, through the appraisals and other means of the court, continued to argue that it was worth $410,000, and the reason for that was specifically to increase her equity in the marital home for purposes of alimony and any equalizing payment that she was going to be getting. And then after the fact came in and decided that actually the $260,000 would be adequate now that her father purchased the property.
Let me go back to the auction. And there's this testimony that was presented. Question, are you aware who this third bidder on the property was? Answer, the bidder 12192, correct. Answer, yes, I believe it was a Miss McCathan, who I believe was representing Mr. Seaman in the bids. The lawyer says, I don't have any further questions. And then counsel for your client then does redirect examination and asks 0 questions about that answer. Why isn't the trial judge allowed to rely upon that as an established fact?
I think that the trial court is allowed to rely upon that as an established fact. if
Okay,
she would
and
like.
so if the trial judge is allowed to rely upon that as an established fact, then you've got evidence in the record that your client made a bid within the same realm of the wife's bid. Isn't that evidence of the reasonableness of the bid? How can your client come in and bid, let's say that your client comes in and bids $21,000, and so the other side then bids $27,000. And now you're going to come to us and argue, well, a bid in the $20,000 is patently unreasonable when your client made that same bid.
I understand what you're saying, and that the court's allowed to accept the testimony and the inference, but in this case, it wasn't our client who made the bid, and our client would not.
No, but I'm sorry, that evidence comes in without objection and without cross-examination on it. And so the trial judge relies upon it as an established fact. And I don't see any reason that we would take any different position, that that's an established fact in the case. I mean, we're talking here abuse of discretion, or as you put it, gross abuse of discretion. And so if the trial judge has that fact, how can that be an abuse of discretion?
I mean, I would submit to you that the trial court doesn't necessarily have that fact. I understand that if she wants to make that inference or accept that testimony as true, she can. She also had the ability not to accept that testimony. And I don't understand where she could have, other than him just saying it, what additional evidence there was to show that.
But he's got a lawyer there. He's got a lawyer at the hearing, and if that's untrue, don't you think the lawyer would perhaps ask a couple questions about it? Like, excuse me, you just testified that this bid from Ms. McCathan, who was representing Mr. Seaman in the bids, can you explain to the court your basis for that testimony? Or isn't it true that you don't really know who Miss McCathan was bidding for? I mean, you could come up with any number of questions, but wouldn't you come up with some questions about it?
Yes.
All right. Okay.
I can reserve the rest of my
Okay.
time for rebuttal.
All right, thank you.
May it please the court, Michael Cooper from Ocala on behalf of the appellee Allison SEAMAN. The issue before the court today, the sole issue, is whether or not Jennifer Bass committed an abuse of discretion in her findings in the 11-page order she submitted on this case on September 20th, 2018. The record, the transcript, the order itself, the appellee brief, all demonstrate that there was no abuse of discretion, that her order was well formulated, well considered, based upon specified facts and law, and we would ask that this court approve that order and confirm it. Thank you very much.
McCathan testified at the hearing, correct?
Yes, Your Honor.
And did McCathan testify at the hearing who she was bidding for?
She did not.
Nor were there any questions on cross-examination about who she was bidding for?
And before I even made it back to my office that day, I realized I made a mistake. I should have asked that question. I did not.
All right. All right, thank you.
Thank you.
Any other questions?
No.
Okay.
I would just briefly like to discuss our issues relating to the collusion and the mistake of the bidding. I think that just on the face of the record alone, you can look to see the collusion based on the players that are involved here. So the people who attended the hearing were Ms. SEAMAN and her attorney, who was also the attorney for Ms. SEAMAN's father, who was ultimately the highest bidder. And then on behalf of Mr. SEAMAN was Austin and Lorado, and then there was the clerk and Ms. McCathan. So the point that we've been trying to make, I think, in our brief and at the hearing was that the wife, through her attorney, is the one who objects or files this response to our objection saying that the amount of money is adequate, even though it's a complete flip on her position throughout the entire dissolution proceedings. But ultimately, what we want the court to look at is that the wife's position, if she's really not gaining anything through her father's purchase of the property, should be that she should want the most and highest amount of money to be gained from this auction sale. And essentially she came in and she said that that's not what she wanted. And instead, whereas her father's position would be to spend the least amount of money and get the property for the lowest price. We had somebody come into the hearing, Ms. McCathan, ultimately willing to testify that not only would she have paid $28,000 that she tried to bid on, but she also tried to bid $50,000, and she was there willing to put that amount of money down for the purchase of the property. And ultimately, the wife was adamant through counsel that she did not want to accept or ultimately get that much more money, which would have doubled the amount of money that she would have made in the sale. And the only thing that we can sort of conclusion we can draw from that is that she's ultimately going to benefit in some other way from the sale of the property to her father itself. So that's where we think that the collusion comes in. There's no other reasonable explanation we can come up with as to why the wife would take this position, and then in the same breath, moments later, there would be a petition for the certification of title argued by the attorney for the actual attorney to take the title, the property, then to just a few days later give it over to the father. Ultimately, once the trial court was apprised of all of these circumstances that we went through, all of the different ways that the wife and the father had worked together, that the father had ultimately paid an amount of money that was just enough for the husband to realize zero equity in the property, it just seems that those circumstances surrounding the sale, the judge should not have confirmed the sale, and we would request that this court reverse for nothing else other than to discourage these collusive practices, and essentially ask that this order on appeal be reversed and that the instructions would be to re-advertise and resell the property when it's clear that there are people willing to purchase the property for additional funds than were realized.
And in the divorce case, is there any reason that the value from the auction wouldn't be admissible in the dissolution case?
What do you mean?
Well, you had a bid of, $27,000, and then you've got the mortgage on the property, and for purposes of determining the value of the property in the dissolution case, could that figure be used?
The money that was actually realized? I think that the money that's actually realized is what should have been used in the dissolution case. In our appeal for the dissolution, one of the biggest arguments was that that money was never going to be realized, and that the court set such a high number, and there was no way to get those funds.
Okay.
So I think that that ultimately whatever actually came should have been the number used for the dissolution.
Okay, all right, thank you.
Thank you.
All right, we'll be in recess.